Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Mashegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Happy hump day. Today is Wednesday, November 13th, 2024. And today we're going back to Dedham. And we're going to see Hank Brennan's debut. This is the first time that he's appeared on camera in this case. Hank Brennan, for those of you who don't know, is a defense attorney who has been hired as outside counsel, as a special assistant district attorney in order to re-prosecute Karen Read, because apparently nobody in the office wanted to touch it. Hank Brennan is most famously known for representing Whitey Bulger in Whitey Bulger's criminal case. And he has a contract with the Norfolk County DA's office at the shocking low rent rate of $250 an hour. He's under contract with the Norfolk County DA's office. And he's $250 an hour is about a hell of a lot less than the average lawyer, I guess, in Boston would be paid. I mean, here in New York and LA, lawyers are charging upwards of $1,800 an hour. So $250 is a bargain basement rate. There's a cap on his contract of up to $75,000. And that contract is due to expire in June. However, as we've seen happen in the Ken Mello contract, they can often be extended and increased, and the cap can be increased. So this will be very interesting. So we will see. I think this is the first time we've seen him on camera, right? He hasn't appeared in this case yet. I could be losing my mind because, this case will do that to you. I've got the Zoom feed up for the hearing, and I've got the NBC 10 says that they're going to be broadcasting it live, but then they also said we're going to be bringing you updates live. So if anybody knows, because sometimes the Zoom feed is not great, of anyone else who is either broadcasting it live, a network, not another streamer, a network like Court TV, Law and Crime, Boston 25, Boston 10, because sometimes they have better audio. And I think Boston 10, maybe it's going to be on their website, but I've got them both up, so we're here. We're here for it. Wow, a lot of new members this morning. And look at Susie Costello with a $50 super chat to start off the morning. Thank you, Susie, for thanking me for all that I do. And thanking you for being here. I'm thanking all of you for being here, because without you guys, I don't have a channel. So I do appreciate each and every one of you. I know that you have many choices to watch your LawTube coverage and coverage of Karen Read. And I am so honored and grateful that you come here to choose to spend part of your morning with me. It's a motions hearing today. And let me just hold on. Boston 10 came back on. Here.
So to dig deeper into all of this, our Lauren Melendez live for us in the newsroom this morning. Break it down, Lauren. What's at the core of this?
All right, so listen, William
This is
Reed,
live.
he's really been a major focal point, Melody, for the lead up to this Karen Reed retrial, but really for the prosecutions. The new 27-page filing just submitted on Tuesday. This is from her lawyers detailing a lengthy request for the judge to actually deny those prosecutors access to William Reed's Verizon cell phone records. Prosecutors for Karen Reed murder retrial, they're adamant that Mr. Reed apparently made some sort of conflicting statements about his daughter, which they believe is hidden somewhere in his calls or his text messages. And they think it's around the time Boston police officer John O'Keefe was killed in January of 2022. According to them, Rhee is the one who drunkenly backed her SUV into O'Keefe. That was her boyfriend at the time during a blizzard and left him for dead. Reed's lawyers, of course, opposite this, they're fighting to prove that Reed is being framed. They've referred to this manhunt for her dad's records as a, quote, fishing expedition. And they've said in their plea, Massachusetts State Police, they've searched William Reed's phone. They never even called him as a witness during the first trial, and then doubling down, calling that request an, a, quote, invasion of privacy. So again, Reed's hearing, that's later today, Norfolk Superior Court, scheduled for 10 this morning. We've been on top of it this entire time. We're going to be there for that, and we'll bring you live updates as well. Reporting in the newsroom this morning, I'm Lauren Melendez.
Okay, there were
Lauren,
so
thank you.
many
Look, in
things
Stamford,
wrong with
Connecticut,
everything that she
Michelle
just said. So many things wrong. Number one, they did not search Bill Reed's cell phone. She said that they already searched his phone and they didn't find anything. That is not true. They're also not alleging that Bill Reed made inconsistent statements. They're alleging that they may find some inconsistent statements of Karen Reed inside of Bill Reed's cell phone records somehow. So this is what happens when mainstream media tries to report on cases like this. That's just not accurate. It's just not. You guys, we read the whole thing together last night. So they wonder why mainstream media is dying. This is a motion. Well, the one motion that she was talking about is the Commonwealth has made a motion for Karen Reed's dad's cell phone records, Bill Reed's cell phone records, because they believe that there may be some conflicting statements by Karen in his cell phone records. The problem is they already have all of, they want like the phone calls between Karen and her dad and the text messages between Karen and her dad. But the thing is, they've had Karen's phone since the date of the incident and they've extracted it. So everything, all communications between Karen and her dad are already contained in everything that they already have. So they don't need Mr. Reed's cell phone records. It's just another example of overreach. It's another example of trying to invade his privacy or, you know, anybody's privacy in Massachusetts, because quite frankly, the defense had a hell of a time getting records from anybody who was even at 34 Fairview on the night in question. So they asked for not only his cell phone records from the midnight until something like, I can't even remember, 5 p.m. on the 29th, but they also want 1 month prior to January 29th to show the pattern of the calls between father and daughter, which was, desperado, because they want to find out how many times Karen called her father in the middle of the night. And we went through the records last night. She didn't call him in the middle of the night that night anyway. She called him at 6:30 in the morning after John was dead. And we looked at some text messages between them where she called her dad. He didn't pick up. Then he texts her and says, I just got your call. I'm awake. And then she texts him back, John is dead. So, look, they're saying they want to call Mr. Reed as a witness. Bring it on. Bring it on. Call him. He's going to be the greatest witness that Karen Reed could ever have on her side. And he's an incredibly nice man. I've met him before. I met him the day that I went to court. Incredibly compassionate. He is a huge supporter for his daughter. He's there every single day of the trial. He and her mom both. And they don't want to call him as a witness. Come on, really? You're going to call him as a witness? Okay, go ahead. Go for it. They're also trying to get the outtakes from an interview that Ted Daniel did with both of her parents and her brother, because they're going to try and say that there's maybe something in the outtakes about a confession that Karen may have made to her parents. But, you know, that's also a fishing expedition. They may get that. I don't think it's going to help them at all. But listen, Hank Brennan's new on the case. He's got to earn his money. And that is what he's doing. I'll allow it. 6:30 is not the middle of the night. My dad wakes up at 4:30 every day. And she had just found her boyfriend's dead body. So there's that, you know. But, you know, this is people who are close with their parents call their parents a lot and at odd times. She called her mom, I think, at 1:30 in the morning. Her mom didn't pick up. But you know, let's see if she grants it. I don't know if she's gonna rule from the bench at all today. I don't know why the Zoom feed isn't up yet. It's supposed to start at 10, but we'll see. What's the over under with her decision today? We'll see. We will see. I don't know that she's going to rule from the bench. She might. Doubt it. I doubt it. Shout out to my amazing, amazing self-appointed volunteer paralegal, Jonathan Rubin, who is a New Yorker, transplanted in Massachusetts, who supplies me with all kinds of documents and information that are it's just impossible to get. But you know what? Jonathan gets it done. So if you see him in the chat, give him all the props because he is an amazing help to me. And I really appreciate everything that you do, Jonathan. Everything that you do. And you're a New Yorker too. So, you know, there's that. Here's a little something. Let me take a quick look at it. Still waiting. If mods, if you see anybody drop in the chat, another place that's going to be streaming this other than Boston 10's website and the Zoom link that I already have, please text me and let me know. It is 39 degrees in Dedham right now with a wind chill of what? Let's see. Feels like 31 degrees. It's real cold. I was watching Tom CPU and there are a lot of people outside the courthouse. He also had a walk-in of Karen. Oh. Looks like the Commonwealth turned over some some internal affairs reports. We'll look at this after the hearing. Interesting. They dropped this yesterday. All right, yeah, another discovery dump yesterday by the Commonwealth. So we'll take a look at that after the hearing because we don't want to be late for the hearing. We don't want to miss it. Yeah, shout out to them for being in the cold today. They're out there. And somebody was assaulted by a sign because the wind was so hard, really. Oh, man. You can't make this stuff up, you guys. You can't make it up. There are a couple of blue shirts out there. Only, I think Tom said there were only about 2 out there. I can rewind to the part where he caught Karen and Mr. Reed going into the courthouse. If we have time, we'll play that. How is everybody doing this morning? I've got it queued up. Let's see if these people on Boston 10 are going to say that they're going to stream it live. There's a lot of trials happening today on all of the usual suspects like Court TV and Law and Crime, so they may not have cameras there today. Thank you, Justin Green, for the Cash App. Good morning to you, sir. Thanks for tuning in. Let's take a look at the walk-in. This is Tom CPU. He's always outside the courthouse. If any of you are not subscribed to him and you like the outside the court coverage, go check it out.
Good morning.
Okay, so is that Craig? Is that Craig of the tiny desk? Wait, or is that Alan Jackson? Hold on a second. Let's just see. This is as the Reed parents walk in.
What? Wait, well, just wait. Just wait. Is this live? Yeah.
That's Tom. It is Craig. Craig's here. Craig of the tiny desk.
Yeah.
All right.
You want to give a couple words? No, I'll be all right. I'm just here spectating today, man. Spectating. Yeah. The movement has taken off. Mr. Reed's here.
Oh, where is he? Coming across.
Oh, Tommy, we lost you. Wow.
He comes back in a second. I was watching that live.
Shelby, you want?
There's Mrs. Reed.
How you doing, Mr. Reed?
Thank you all. Good morning.
Yeah, you got to go to the bathroom. Let him go.
Clear the sidewalk, people. Get some sidewalk. Bang. Good morning.
Craig is here.
Mr. Beard playing Mr. Jackson. Some people like it, some don't.
Miss Cianetti. Eliza. Did anybody see AJ? Did I miss it? You guys remember? I had Craig on my channel one day. We had a great show together. Yeah, I don't know that Craig would be here for this. So did Alan shave his beard? Now I'm a little, it's kind of blurry. His footage is a little bit blurry. Do it again.
How are you? Hi.
Here's
How you
the
doing,
first
Mr.
one
Reed?
to walk in. Let's see,
Thank
behind
you all.
Mr. Reed.
Yeah, you got to go to the bathroom. Let him go.
Clear the sidewalk, people. Get some sidewalk. Bang. Good morning. Mr. Beard playing Mr. Jackson. Some people like it, some don't.
Hey.
We did a poll the other day on AJ's beard, and it was the overwhelming favorite was yeah, let's keep the beard. Some of you are here for the beard. Some of you have changed your name for the beard. I don't think Craig would fly in for this, so I think that was Alan. It was just hard to see. You can see how many people are here today. So great show of support for the Reed family. Very happy that they are being supported through all of this, because as we learned from the Vanity Fair article, Karen Reed is over $5 million in debt for legal fees. And Karen Reed could be you or me or any one of us. Let's see, WBZ. Zoom still has not started. All right, several requests will be discussed this morning. One of them is the motion about Bill Reed's cell phone records. As you know, the defense has also asked for Michael Morrissey's personal email and phone records based on discovery in one of the Bettero bombshell letters in the Aidan Carney case. It was discovered that District Attorney Michael Morrissey, who is prosecuting Karen Reed, is had been using his private email server to email judges. Specifically, they found emails from Michael Morrissey's private email server to judges in Stoughton District Court and other court personnel, complaining about the fact that Chris Albert was not granted his restraining order against Aidan Carney, aka Turtle Boy, and chastising the judge and demanding that something must be done, and that accusing a woman who works in the courthouse of leaking information regarding that case, which, by the way, is a public filing. And then, although the restraining order had been denied before he sent that email, all of a sudden, a couple of days later, it was granted. Interesting, huh? Interesting. So they're asking for Marcy's private emails and text messages, because once you use your private email as a public servant, those become discoverable. We'll see what she does about that. They're also requesting that the sidebar transcripts be unsealed, because, as you know, everything during the trial was discussed at sidebar. All the evidentiary rulings were at sidebar. And the defense says we can't properly prepare for our motions in lemonade, as we've come to call them from the closed caption error one day, unless we have those sidebar transcripts unsealed. And if you don't want to unseal them to the public, at least you should unseal them to us, because we need them. We need to know what the rulings were, Judge, before we can make our motions again before the retrial. That is another motion. They are also looking for, the Commonwealth is looking for the unredacted audio recordings of the Ted Daniel interview that he did with Mr. and Mrs. Reed and Nathan. And also from Gretchen Voss. They're looking for Gretchen Voss's off the record, because there is no such thing as off the record in Massachusetts, you may recall. Off the record and notes that were not granted the first time around. So it shouldn't be too quick. I mean, I'm expecting that we're going to be here for a little while, if she allows them to, argue, which she should. So there's all that. Let me see if so is WBZ going to be doing it on their website, do you think, or on their YouTube? Let's see. I like to find you guys the best audio, as always. Oh, here it is. It's on YouTube. Okay, good, because it takes up less power. And when I have so many millions of tabs open, as I often do, I like to conserve my opened tabs. Good morning. Good morning to almost 4,000 of you. We're 5 away. We're an hour at 4,008. If everyone would just take a second before we get started to hit the like button before we get going here, that would be amazing. I appreciate you so much. Oh, thank you so much. I appreciate you. I'm going to pull up the first thing I'm going to pull up, since it's already at least the screen is up. We'll just keep it up here so we don't miss a thing. And then when they get started, we'll be ready to go. They have their comments turned off on WBC. They have their comments turned off, but why can I not full screen it? I guess because it's not up yet. All right, well, it's here. Never fear. We won't miss a minute. Thank you. They're calling me the icing on the cupcake of law. That is very sweet of you. All right, let's welcome in all the new members. We have a lot of new members this morning. Welcome to Deborah Claire, Kevin, the Sally Port camera. We have the funniest chat on YouTube. You guys are called the Snark Tank, and it's we got to keep laughing, you guys. We just got to keep laughing, or we're gonna cry. So thank you for keeping me laughing. Amy in Boston, a new member who's been a member for a long time, as has Stephanie, maybe just re-upped. Who, if anyone, thank you for becoming a member. Lisa T, welcome. RL South, welcome. Cheryl RV's Travado Travels. And look at this. The Glare is my boyfriend, became a new member. I think you had a different name before, right? But I guess you guys are a thing now. So congratulations. And welcome. Rosalie, thank you for becoming a new member. Angela, Susie Costello, Cheryl's RV Travado Travels. I don't know why that came up twice, but it did. M became a new member. Rassler's mom is back again. And Sonia. And again, Susie, thank you for the very, very generous super sticker to start off the morning. Let me just delete some of these so that we have a fresh second column over here. I heard that StreamYard was having problems this morning, but luckily it didn't affect me. Mark McKay, thank you for gifting a membership, and to whomever was gifted, welcome. I think you're going to like it here. Wanda, thank you. Thank you for watching. Because without you and people like yourself and all of our like-minded folk here, we wouldn't have as much fun. KLM, thanks to the 5, says, I'm not from Massachusetts, but I see on YouTube WBZ CBS Boston has a link up to stream. Thank you so much. Thank you so very much. We've got it. And I think you're the one who gets credit. All credit to KLM. Mom of two boys says that's AJ, not Craig. It did kind of look like Craig, though, right? Although Craig is a lot taller, I believe. Well, I guess we'll see when we get a shot of the courtroom. I don't think they would fly Craig in for this. I just don't. But we love Craig. He did a show with me, and it was a great show. And it was really nice to meet him in court and also through the show that we did together. Barbara Dulong, thank you for the 5 so very much. Marcello's here from Argentina. Are we ready for the size, guys? Members, get your special emojis ready. Because we make special emojis. That's a member perk that we have for all the trials that we cover. And for this case, we have so many of them. So many. We've got smooth as butter for Alan Jackson. We've got a sigh emoji for the judge and Adam Lally because they both used to sigh a lot. We've got a big salad, which is not only a Seinfeld reference, but also for the word salad that so many of the witnesses seem to use. We've got a set of handcuffs for whenever you feel that's appropriate, a leaf blower, a puffy jacket, a solo cup. What, if any? We have We Are Outraged, which, as you know, was during pretrial. I think David Yannetti said that. We have Wait for Us, which was in the opening statement. Wait for us. We have a rubber ducky, if you know, you know. The fan. Wow, we have a lot related to this trial and a lot that can nope. We heard nope a lot. We've got lies, lies, lies. Yeah, about the Thompson twins, a couple of Twilight Zones. And it's a lot of fun here. It's a lot of fun. Word salad with a sprinkle of lies. Hi, Laura. Where you been? Where you been? Melissa, thank you so much for being with me for 2 months. I appreciate you. Motions and lemonade and salad sidebars. Very good, Vivian James. Very good. Thank you. Welcome to Melissa. I'm Just a Girl in the World. Get to 5 memberships. Thank you so much. I'm Just a Girl in the World. I appreciate you so much. Just want to make sure I'm muted because the Zoom just went on. And you know, sometimes they forget to mute people. How do I know if I'm muted? Can I assume that they just mute everyone? Guess we can never assume, can we? I don't know. It's weird. It's like a whole new format. See, it's like this. Free Billy Tibbets. Free Billy Tibbets. Like, there's no way to see if I'm muted. Can't see who else is in here. That's all they're giving me. I don't want them to hear me. Free Billy Tibbets. Well, I have CBS Boston right here. I've got it. So as soon as it starts, it'll come up. All right, we'll see what we get. We've got it, but we've got both. We've got everything. I know. That's why I don't know. I gotta make sure I'm muted. I mean, I know I have it set to be muted when I enter. I want to be the Free Billy Tibbets person, you know? Be nice. We're the chat whispers. We're the chat whispers. Please don't tell me what to do. I don't want to be on the Zoom feed. I don't want my audio on the Zoom feed. Okay? Please don't tell me what to do. Billy Tibbets is the guy who's in jail. He was a hockey player. Is he still in jail? But during one of the Zoom hearings in the Karen Reed trial, somebody during the Zoom feed, because they didn't know how to mute everyone in the Zoom feed, said, "Free Billy Tibbets. Free my boy Billy Tibbets." I know. It's going to be the different courtroom today without the fan. And they could be getting ready. Oh, here he is. My favorite volunteer paralegal. Everyone say hi to Jonathan. I hope everyone's muted, but remember the Free Billy Tibbets thing. Remember that. Jonathan, you know about Free Billy Tibbets. Oh. It was on and then went off. From your mouth to God's ears, Jonathan. Why? Lakeshore Drive, why? Why did you leave? It's ASMR. Oh, I can't unmute myself. Yeah, but listen, if you guys know about Free Billy Tibbets, you would understand what I'm talking about. Because originally when the court started doing this on Zoom, they didn't know how to mute people. And everyone was there. I have WBZ up. They're streaming it live too. We're good. Got them both up. We're hunting rabbits. We're hunting rabbits. I already thanked you. I'm just a girl in the world, so thank you. Prestige Worldwide. The band is back together. She's back. Yay, she's back. Bemi Rose, thanks for becoming a member. Prestige Worldwide gifted 5 memberships. Thank you so much. I appreciate you. As always, girl. Appreciate you so much. Welcome to the new 5, the new Fab 5. Audrey, thanks for becoming a member. That's so Jessica gifted another 5 memberships. You guys, we're up to like at least 15 gifts today. So you got to be opted in. And if you're opted in, then you have the opportunity. Hold on while I just listen to this voicemail. Okay, not what I thought it was going to be. Thank you. That's so Jessica. I appreciate you so much. We also have a Rage Crochet Club here, which is pretty awesome. So those of you who are in the Rage Crochet Club, introduce yourself and welcome in some new members. Melissa, thank you so much for tuning in from down under and for appreciating my analysis. I appreciate you, all of you, so very much more than you know. Pauline, thanks for becoming a new member. And Lori Life 360 gifting 5 memberships too. Are we up to at least 20, 25 memberships that were gifted this morning? In order to opt in, there's something you need to do with 3 dots on the on your screen and opt in, and you have to be like participating in the chat, and then you become randomly selected by YouTube. I don't have any control over it, but thank you, Lori Life 360, for the win. Another person who changed their scream name to go with the Karen Reed trial. Thanks, Midnight Mike, for your super sticker. I appreciate you very much, as well as your 10. KOB, good morning. Oh, thanks for appreciating me. I appreciate you too, KOB, and thanks for the 5. P. Kaser's been hanging around for 6 months with a bunch of hearts. Thank you. My pal Sal became a new member. Thank you. Welcome, my pal Sal Vintage. Ducking Bianca. There's a good example of someone changing her screen name to go with this trial. Ducking Bianca. Good morning. Could not watch this anywhere else. Thank you. Thank you. Look, we've got over 5,000 of you here. If you would hit the like button, it would really help the algorithm. Share the stream out. Always feel free to do that because I don't do Twitter. So some of you do. And I know that some of you like to share it on Twitter, and I appreciate that so very much. Lois Lane, let's have Melanie get to 100K. I'm gifting memberships soon to help. Stay tuned. I hope I'm allowed to say that. Oh, you're very sweet. Yeah, no, we want to get to 100K, but it's 100K subs, and subs don't cost anything. So, yeah, that's amazing, and I appreciate your generosity. As always, Lois Lane, I appreciate you. Just waiting for them to start. Thank you, M. Monge 1967, for becoming a member. And Fairy Raven has been with me for 9 months, at least 9 months, and always a pleasure to be here from Ireland. She's tuning in all the way from Ireland. Thank you, Fairy Raven. This is a worldwide story. You guys tell everyone where you're watching from if you're international. We have a huge international audience. That's why these morning shows are good. Sarah Bree Creative says, see the glory of the royal scam. Steely Dan, I think, in song lyrics. Thank you, Sarah, for your super chat. Proud OG Cupcake. That's right, New Hampshire woman. You've been with me since Kevin Costner. Thank you so much for the super chat. God save the Commonwealth, Kirsten. Formerly Anti-Bev's Verdict Forum. Now you're going to think of a new name, I think. Tuning in from Canada to say God save the Commonwealth and Fui Bailey Tibbets. Midnight Mike gifting a membership. Thank you, Mike. And welcome. And another 5 from What the Duck. Really, you guys are really overly generous this morning. I don't know if I can even fully appreciate it so early. I haven't spilled my iced coffee yet, so that's we're stepping in the right direction. We're stepping right in. I'll find my words, but thank you so much. If anyone who ambulance driver, thank you, says I was inspired to change my name. Oh, was there for a second and now it's gone. Thanks for the super chat. Lois Lane giving 10 memberships. I can't even. You guys, I can't even. Thank you, Lois Lane. And then Lupus Lady with another 5. I mean, I'm going to have to go back and count later, but you guys are overly generous today. Thank you. So I really, really, really appreciate it. Thank you, Lupus Lady and Lois Lane. And Georgie Girls 1217 became a YouTube member. If that's your birthday, it's coming up soon. Lori, thank you for your super sticker. Lori 909. Kes Chick became a member. We're just waiting for the Zoom to start. If you're just tuning in, we also have WBZ up. They say they're going to be streaming it live, but their camera's not up yet. And their audio is also not up on this feed, but let's make it bigger for now. I can see Alan Jackson still has his beard because he took your poll seriously, guys. And you can see Alan Jackson in the center of your frame. To the left of the screen is Eliza Little, no relation. To the right of Alan Jackson is Karen Reed, and to the right of Karen Reed is David Yannetti. In the front row, center screen, Adam Lally is back. To the left of Adam Lally is Hank Brennan, the new Special Assistant District Attorney who has been tapped to come in and try this case as a hired gun. And this, I think, is Ms. McLaughlin. And I can't recall her first name, but she's an attorney with the District Attorney's Office. She second chaired Adam Lally during the first trial, but I don't think she questioned any witnesses. Adam Lally really carried the entire first trial on his back. He did everything. I mean, he was a one-man band on that first trial, and that is not an easy job. Not an easy job. Thanks, Kes for becoming a member. And Debbie for hanging around for 11 months. Says, good morning, cupcakes. Is it really legally binding when the court says recording is prohibited? I don't know. It's a good question, Blackberg Sweeks. I'm a New York lawyer. I'm not up on my Massachusetts law, but I don't know. Thank you for the 5. Cher Kolaki became a YouTube member. Welcome. And Nathaniel Brown also became a member. Welcome to you, sir. Chef Sherry's got her caffeine. Hope it gets me through Auntie Bev's size. Thank you, Chef Sherry. Chief Sherry. Chief. Sherry, you're a fire chief, right? Or a retired fire chief? Yes, I remember. Thanks for the 10. Wanda D gifted a membership. Thank you, Wanda. Don't worry, you're not missing anything because the sound's not up yet. Abby and Rosie's mom became a new member from Canada. Thanks, Abby and Rosie's mom. Welcome. Susan Costello gifting 10 memberships. Thank you so very, very much. That's a lot, you guys. We've got, I don't know, I think we're pushing like 100 gifted memberships already this morning, and we just getting started. Like Coach Prime says, we coming. And now Coach Prime says, we here. I'm going to be at the Colorado game on Saturday. If anybody in my chat, any of my Colorado friends are going to be there. Playing Utah. And we are now, I think, number 18 in the country. SCO Buffs. I also have a Buffs emoji. We've got a Buffs emoji because I am a proud alum of the University of Colorado in Boulder. And then I loved Boulder so much I didn't want to leave, and I went to the University of Denver Law School, but still lived in Boulder and did that commute every day when the law school was by the old airport. Thank you, Susie Costello, for gifting 10 memberships. And for Fox's sake, or for Duck's sake, you could be. Good morning, fellow cupcakes, and to our queen, Miss Melanie. Happy Wednesday, all. Happy Wednesday. It's hump day. Hump day in Norfolk. Once again. Looking like a packed house there. I don't know how many seats they have open to the public today, but there's a lot more seating than there was during the first trial. During the first trial, there were no seats available to the public. Exactly 0 seats were available to the public. There were 10 seats for the defense, family and friends, 10 seats for the victim, O'Keefe's family and friends, 10 seats for media, and that was it. That was it. It was a small courtroom. And the reason that it was a small courtroom is because the courtroom they were originally going to hold the trial in had the jury box positioned so that certain members of the jury who were seated in certain seats could only see the back of witnesses' heads. And the defense made the motion like, Your Honor, we got to either move the jury box down or move the seats around because the jury needs to see the witness's face while they're testifying. And the judge actually said, this is the way we've done it here in Massachusetts for 100 years. And I think smooth as butter, Alan Jackson might have clapped back and said, well, I don't care how you've done it for 100 years. It's unconstitutional. Could you imagine the jury only seeing the back of witnesses' heads? I mean, really, could you imagine? Everything you need to assess a juror's credibility is in their facial expressions and their face and their tone of voice and their body language. And so it was switched to a smaller courtroom and no members of the public were allowed in. But that's a trial that was live streamed. You know, I went to Daniel Penny's trial yesterday in Manhattan Criminal Court, where I ran into Mark Betterow. They had 30 seats available to the public, but there are no cameras in the courtroom. But people are live tweeting from that courtroom. Delphi had something like 20 seats maybe for the public. All right, well, they're standing, so the judge is coming, but where's the sound? God save the Commonwealth. Put the camera on him. Put the camera on him. All right, you guys, I'm going to switch to the other feed. Because we're going to have the ability.
Might have a preference that I remove to the podium. Would you like me to answer?
It's wherever you're comfortable, as long as we can hear you.
Your Honor, I filed a series of Rule 17 motions. As I'm sure you're aware, I have not notified any of the third-party holders. I did not want to.
Here's what we're going to do. We're going to switch over to. We're leaving the Zoom because we can't see the judge. We can't see anything. It's going to be only one angle. I want you to have a better angle. I want you to have better sound. We're going to scoot on over to WBZ because we have the ability to rewind. So we're going to take this back to judge coming in. And this way we're not going to miss a thing and we're going to have a better angle. All right. And here we go.
Agenda during the hearing today with the possibility.
The defense.
Good morning, Your Honor. Alan Jackson on behalf of Ms.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so we have a series of motions here. I expect we may be here a while this morning. It makes sense to me to start with the Rule 17 motions. So the first Rule 17 motion I have is the Commonwealth's motion for records from Verizon. But I do have a question for you, Mr. Brennan. Have the third-party record holders been served in all of these Commonwealth motions pursuant to Rule 17?
Thank you, Your Honor. I understand the court might have a preference that I remove to the podium. Would you like me to answer?
It's wherever you're comfortable, as long as we can hear you.
Yeah, don't argue
Your Honor,
with your
I
back to
filed
the
a series
defense.
of Rule 17 motions. As I'm sure you're aware, I have not notified any of the third-party holders. I did not want to be presumptuous, seeing that I have not met the court and didn't know what the schedule would be for the Rule 17s.
Oh,
So I have filed these just to give everybody as much notice as possible. And my intention was to ask the court if we could set a date so that we could have these motions heard and hear the defendant's objections.
okay.
That's not the way we do it in
All right,
Massachusetts.
So I misunderstood. I thought they were on for the Rule 17 motions today. All right.
Yes.
So the record holders do need to be heard. I was wondering why I did not hear from any of the parties other than I have the defendant's objection to Mr. Reed's records. But all right, so we'll get a date, and that date should be sooner rather than later.
Come on,
to
man.
Get notice out to all the parties.
Yes, Your Honor.
basic.
I'll note that we did file 2 additional Rule 17s last night. I don't know if they've been docketed.
They have been docketed. I got them, and that's why I was wondering whether the record holders had in fact been notified. So, okay, so scheduling we'll do at the end of the hearing. Then I think what we'll start with after these Rule 17s that we'll put on.
I just want to point out that that's basic. When you serve a motion for third-party discovery, you're also required to serve that same motion on the person that you want the discovery from. Like in this case, it would be Verizon, so that they have an opportunity to come in and object if they want to. They just need to be on notice of it. And for him to say, "Oh wow, I didn't know we were going to be, arguing that today," it's kind of like the earliest motion that he made. So that's kind of a basic mistake. Now they're not going to argue that motion today for Bill Reed's cell phone records because the Commonwealth did not properly serve Verizon.
Pause. It's paper number 48. It's the defendant's motion for relief from the order to impound sidebar conferences. And before we begin that, is there an opposition to that from the Commonwealth?
In part.
Okay. All right. Have you spoken with Mr. Yannetti about what part that is?
I've spoken to all the attorneys numerous times. I think we're very clear what each other's position is.
Okay. All right, why don't you, all right, Mr. Yannetti, do you want to be heard by starting with the whole motion or what?
I think we can short circuit this, Your Honor. Our suggestion, I think it's a joint suggestion to the court, is that the sidebar conferences be unsealed solely for counsel at this point. Mr. Brennan's at somewhat of a handicap because unlike the defense team, he was not present at sidebar. He does not know what the conferences were about. And in fairness to the Commonwealth, we've agreed that it just be released to us, and then Mr. Brennan can decide if he has a further position regarding unsealing it more than that.
Okay. All right, that makes sense. Have you spoken with Ms. King about how long it will take to get these transcripts?
My co-counsel has spoken to her only.
Which co-counsel?
Mr. Jackson.
All right. What do you have to say about that? How quickly can she get them?
She works extremely expeditiously, but she has not started them, to my understanding. There's 3 reporters who probably would split the work.
Right.
And she said that she could get started as soon as there was a court order suggesting that she do so. I would imagine, given what we've gotten so far, we're talking a couple of weeks rather than a month or 2. I think we could probably get something within a few weeks.
Okay.
2 to 3, I would guess, just based on my experience with Ms. King.
All right. Even though it's just for counsel, do you intend to have, are you asking me to unseal the sidebar conferences with the jurors?
Just for counsel, yes. I would imagine that when we get to the second stage of this, those would be in a different category from the legal rulings at sidebar unrelated to jurors.
All right. All right. Thank you.
If I could be heard briefly.
Sure.
Thank you. Regarding non-juror information, I'm in full agreement with the defense. I think it's prudent to, if the court would consider unimpounding the documents, I can review them.
Look, I know this is the way that you do things in Massachusetts, but I see Bob Motta is here. Do you think it's rude that he stands up and has his back to defense counsel? Because the way this courtroom is set up is ridiculous. It's like the Commonwealth table is like attached to the bench, like they're one and the same. I mean, it's just so wrong. They're not side by side. Get up, go to the podium, and let everyone see you and hear you. It's just, in my opinion, it's kind of rude. And it's hard for the defense counsel to hear him speaking because he's in front of them, speaking in a direction towards the judge. I mean, come on, it's kind of basics.
You can review unimpounded documents. Counsel can review impounded documents.
Then I'll begin that task. And if there's any concerns, I'll note them. If not, then I would have no concern about releasing them outside of protective order. The juror information stands in a different posture, in my perspective. I think that should remain impounded at this point. There's a pending appeal before the SJC based on the request of the defense. If they are successful, would then reinvigorate the attention on those jurors. I don't see a need for juror information to be unimpounded at this point. All the other information, I don't have the same concern.
Okay. All right. Thank you. All right. The next motion. So defendant's motion for discovery of communications in the possession, custody, and control of the Commonwealth. Who's going to argue that?
I will, Your Honor. I would say at the outset that in speaking with Mr. Brennan, he had expressed a preference to be able to respond potentially in writing. So we were in agreement, subject to the court's approval, if we're going to get another date for the Rule 17 motions, to have this motion heard at that time. But I'm prepared now if the court prefers me to.
No, I'll give you the opportunity. How much time do you need to respond in writing, Mr. Brennan?
I can respond by next week.
Okay.
Really, I'm accommodating the defense. I have a very broad perspective on Rule 14 statements. Our office has made a concerted effort to provide everything that's not only discoverable under the rule, but from my perspective, a broader perspective. I want to make sure I err on the side of caution and they get every statement they're entitled to.
Good.
So we're in the process of accumulating all potential statements of witnesses which they're entitled to, and I'm going to provide them to them. I've already provided a number of statements that I frankly believe are outside Rule 14 parameters, and I'll continue to do that throughout this case.
Okay.
And so my response in writing really is to accommodate the request and then give an answer in a production of what I have. That's going to take me probably 10 days to put everything together, to adequately review it, and then to provide a package to the defense. And so I think that if I have 10 days, I might be able to accommodate the request without any need for litigation. If they decide to pursue further effort, then I can respond.
Okay. All right. So why don't we give you, until the 27th, just after or just before the Thanksgiving break?
Appreciate that. Thank you.
Okay. All right. Does that work for you, Ms. Giannetti?
Certainly does.
Misty and Eddie.
All right. So let's talk about the Commonwealth's notice of scheduling, reassembly and testing of the defendant's Lexus telematics system.
Yeah, let's talk about that.
May I?
Yes.
As a matter of background, as I think the court is likely aware, the Commonwealth tested information on data chips that were found in different modules that were inside the defendant's Lexus. Inevitably, at trial, the court is likely aware that there's information taken from one of the systems that was provided, and it showed information such as key cycles and different speeds. And I understand that was a exhibit at trial. There were two different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics module, which is like a lunchbox with computer panels in them. And then in 2023, there was a second search warrant for the infotainment system, which is what was produced at trial. I hired an independent expert, and in the independent expert of the information, what he realized is that the information taken from the informatics manual and the information taken from the telestream manual had some irregularities. What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure.
Okay, so you're trying to now explain away your new expert's misunderstanding of the difference between a gigabit and a gigabyte? Go on with your bad self. I mean, you could try. Okay. This is the excuse. Yeah, here we go.
There was information including navigation information, information regarding the phones that were plugged into the radio, travel logs, things that are particularly relevant and material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case.
Well, it's kind of funny because when we went over the papers last night, the search warrant that Michael Proctor executed asked for all of that stuff. You've already asked for all of that stuff in December of 2022, if I recall. Or, yeah, that was for all the vehicle data information, right? We went through this, Olivia, last night. And now he's saying they never got it, or he's saying they never requested it.
And so after he realized his oversight on the gigabit, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader. So that way the information was not available. Also in the the infotainment system, there were actually 3 boards, not 1. Only 1 was taken out. So there is a plethora of information on these chips that has not been downloaded that's relevant to this case. And so we provided notice to the defense that our intention is that we are going to test this information that we have in our control and that we have a search warrant for. And my effort was to give them notice so they could have an available expert. So my purpose really was not to ask for the defense's permission, rather it was to notice them this is what we were going to do. You can see from my motion, I asked to do it within 14 days. Having recently arrived at the case, it was important for me to prioritize Rule 17 motions and new experts so that they could have adequate notice. The defense asked for today's date and wanted more time, and when I considered it, I thought that was reasonable. I think they're entitled to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it. And so that's why I agreed to this date.
They didn't ask to prevent it. They want to do it. They just want to be there with their expert who knows the difference between gigabits and gigabytes. And just now you're discovering that there's 3 motherboards and not 1. And just now you had your expert Shannon Burgess, the hacker who doesn't know the difference between gigabits and gigabytes, do a supplemental report because he was called out by the defense's new expert. Oh, this is fun.
Inevitably, we know that this information will be on these chips. And so we know there are 2 boards on the system that weren't tested, and then the other chips that were tested that came back with unreadable information with the proper computer programs, they call them programmers, we will get viable information from both of them. And so I've spoken to the defense. I know they've hired an expert. I know they've filed a motion contesting our position. I'm not going to speak to what their position is today. But I would say 2 things. One, the defense in their motion asks to have their expert be able to intervene. We're not agreeable to that. They can watch and comment and criticize as much as they'd want, but we're entitled to the download. Notably, when the first download was done, the Commonwealth deferred to the defense expert to do the download. That is not my position. I don't defer that responsibility. But it was the defense expert that overlooked the proper reader that was needed for the chips that were tested. And it was the expert that overlooked the fact that there was 3 panels in the system, not 2. And our expert was astute enough to find those oversights.
Astute.
And that's why we now have an independent expert that is going to do.
Your astute expert, Shannon Burgess, who doesn't know the difference between a gigabit and a gigabyte, is astute. That's why we now have a better expert than Trooper Paul. Is this what he's saying? Hold on.
Our expert was astute enough to find those oversights, and that's why we now have an independent expert that is going to do this. I know experts differ. They're not frick-a-frack. They all have different opinions.
Frick-a-frack.
We've attached all of the protocol.
Frick-a-frack has entered the chat. That was not on my bingo card today.
What we intend on doing. And the reason I brought it before the court is I wanted to expedite this matter. It's important, and it.
I thought we were going to have that hearing within 14 days when we first got the motion. And then Mr. McDermott told me that the defense was looking for more time, so we gave this. We're far into the case is scheduled currently for January 27th. Sounds like you have a lot to do before then.
She hasn't ruled on that adjournment.
Right now, it's still January 27th. So all of the.
She has not ruled on the adjournment to April Fool's Day that they're asking for, that they both agreed to. And I don't know if she's going to change her mind yet, but she's not happy. And she's not happy with the Commonwealth.
These things, the Rule 17 motions, all of these things need to be done as soon as possible. So
I understand. And if I can just add, it might help in your consideration of a later motion. The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert. And that accident reconstruction expert will necessarily rely upon the information that is gleaned from this testing.
How long is this testing going to take?
It's a 3-day testing. It will take within a week to read it. And the sooner we have it, the sooner we can have our reconstruction expert engage in any type of task that we want them to. But they necessarily are in a holding pattern now. And that is my sense of urgency for this to be developed and done.
Who's arguing this for the defense?
First sense of urgency that the Commonwealth has ever felt in the pendency of this case. Now they've got a sense of urgency. And they've got a new accident reconstruction expert who's going to need this testing to make up his theory, because apparently, even though they had Trooper Paul do 2 supplemental reports and a video and lots of photos, or 1 supplemental report and videos and a lot of photos, that's not cutting it. So they get, once again, they got to go outside. They got to go outside the fold and get a new accident reconstructionist expert. Yes, that's what happens when you have a Trooper Paul.
Okay, I'll hear you, Mr. Jackson.
Yeah, let's go.
Thank
Smooth
you,
as
Your
butter.
Honor. I'll start by saying, in principle, we don't have an objection to the retesting of the telematics or the infotainment center, our system data. The problem that we have, our issue, sort of dovetails into what Mr. Brennan was suggesting about what was done the first time. He just suggested that his expert was his new expert, Mr. Shannon Burgess. was astute enough to find something that Maggie Gaffney didn't find. Well, to bring the court completely up to speed, when the initial testing was done, the Commonwealth's expert did not know how to do a chip off, physically did not know how to do it, Joe Paul. He turned to Maggie Gaffney, our expert, who did know how to do it. She's a former MSP officer and extremely facile in this world of
And you
chips.
have a different expert now. You're not using her now?
Well, we may use her, but we have an additional expert who specifically works, Mr. DeSorga, specifically works in chip-offs and chip-ons. That physical procedure of moving chips on and off of boards. It's a very technical procedure. It's a very skilled procedure. He knows how to do it. He's got an extremely long resume, having done this kind of work.
I read it.
We're bringing him up to speed in order to sort of engage it in some oversight and some observation. I don't have a principled objection to doing the retesting. What I have a problem with is that their new expert, Mr. Burgess, right at the beginning, fundamentally misunderstood the data set on the 3 chips, the 2-micron chips and the expansion chip that he looked at, didn't understand the difference between megabytes and megabits, gigabytes and gigabits, and that gave us pause. If he didn't understand that, which is at the foundation of reading the data, we're concerned that some of the data could be destroyed in whatever process he engages in. Like I said, we don't have a principled objection to the work that's going to be done. We simply want to make sure that nothing is destroyed in doing that work. It's not, and I would take a little issue with something Mr. Brennan said, it's not that the data set is missing information. We don't know that it's missing information. Burla has now updated software that we believe, I think both sides believe, could be beneficial in culling or teasing out that data set from those chips that didn't exist when Ms. Gaffney did her work previously. She put it on a reader, it was unreadable. It doesn't mean that the data is missing. It means that it's unreadable. As a matter of fact, one of the things that our expert would do and would suggest is that a process called a checksum be done. I'm going to use some made up numbers, but let's say there's 5,123 bits or bytes on a particular chip. You can do a checksum and determine that there's 5,123 bits and bytes read now. That means down to the bit or the byte, nothing has been altered, nothing's been changed, and we know that we're dealing with the exact same data set. That checksum would be the first process in doing the additional reading. Then they can go back and use the additional Burla software to see if the data set could be read. After that's done, then my understanding is there would need to be a chip on. They'd need to resolder those specific chips, the 2-micron chips and the expansion chip, back onto the motherboard, install the motherboard back into the truck, and then turn the truck on. That's the process that I understand. My only request is that our expert obviously, given his expertise and his knowledge of this information, he should be there to observe. And the only caveat to that is if he makes a determination, working with Mr. Burgess or observing Mr. Burgess's work, that what's about to happen is destructive to the data on the chips, we would ask gently, and I don't think this is much of an ask, that he be allowed to interpose his objection to moving forward, contact both counsel, both parties, and if need be, present his objections either to us to resolve it or to the court for intervention. That's all. I want the work done, but I want to make sure that the data set that is on those 3 chips or additional chips that are read is never destroyed or in peril of being destroyed. That's all.
All right. Your new response, Mr. Brennan?
Go to the podium like a man.
The
Come
defense
on,
expert
man.
would not be working with Mr. Burgess. You'd be observing Mr. Burgess. The defense expert has no active role in this testing.
Yeah, the defense shouldn't get to participate at all, Your Honor. This is going to be only Shannon Burgess, who doesn't know the difference between a bit and a byte. He's going to be the only one, and their expert can only observe. This is an interesting argument. Okay. Let the know-nothing guy do the work and potentially destroy the evidence.
You'd be observing.
Listen.
The defense expert would not be working with Mr. Burgess. You'd be observing Mr. Burgess. The defense expert has no active role in this testing. There is no inherent risk that Mr. Burgess is going to destroy something unnecessarily. This is potentially destructive testing, just as it was the first time. Fortunately, the information was not destroyed the first time, so we can access it again, but it's potentially destructive testing. The defense is not entitled to veto power during the process. That will delay things. It has no role and no purpose in it. And so inevitably, Mr. Burgess is well qualified. Mr. Burgess is competent, and he is going to test these ships and provide the information to the defense. They'll get into.
Did he say he's competent or confident? Hold on. Can't get closed captions, I don't think, while it's live.
And so inevitably, Mr. Burgess is well qualified. Mr. Burgess is competent, and he is going to test these ships and provide the information to the defense. They'll get an exact copy. The idea of checksum, there's no mystery to these words. There's a protocol that's followed where they use the old software that was ineffective, and they test to make sure it's the same amount of data that's unreadable. And after they confirm that nothing has been moved or destroyed or tampered with, then they bring in the right programs, the right software, and they'll retest it properly. It'll provide the information.
Moved or destroyed or tampered with. The only people that could have moved or destroyed or tampered with it is your people. They're the ones, Garino, who had to disassemble the whole thing, take the whole thing out of the dashboard, destroy things. You've had custody of her car since you didn't even have a warrant on January 29th of 2022. You've had custody of the car. So if anything was destroyed or missing or lost or tampered with, it's your own people, your own new people. Hear that again.
Effective. And they test to make sure it's the same amount of data that's unreadable. And after they confirm that nothing has been moved or destroyed or tampered with, then they bring in the right programs, the right software, and they'll retest it properly. It'll provide the information that will be available to both us and the defense.
All right, so if I act on this motion quickly, because there isn't a basic objection to it being retested, when can they begin, Mr. Brennan?
Your Honor, I spoke to my expert this morning, and I asked him for a schedule when he could test. I told him I'd like it as soon as possible. We didn't finish the conversation. What he told me is December 2nd or 3rd. I told him that would be inadequate. That's too far out. I want it done before Thanksgiving because time is of the essence. And I think it really develops everything else that will happen in this case as far as other experts. So I need to resume my conversation with my expert, encourage him, and insist that we make some changes in schedule. So I can't give an exact date because that conversation wasn't what I was expecting, but I don't think we can tolerate waiting that long.
Okay. All right, this one I will act on very quickly.
Oh, yes,
All right.
of course.
So I think that just leaves us with the motion to continue. I know it's a joint motion, but I need to hear from both sides as to why I should do that. Mr. Brennan?
Can I begin?
Yes.
Yes, Poison Ivy, they do have a right to be there. Does the defense not have a right to be there during the day? They absolutely do. At their own expense, have the right to have their expert there. And that's what they want to do. But they want their expert to be participating in the chip off because their position is that Shannon Burgess, who doesn't know the difference between a gigabit and a gigabyte, is not competent enough to do this destructive testing. Thank you for the super chat.
And the request is for an April 1st date. You're not looking to go any further than that, correct?
We are not. We are not. Your Honor, the Commonwealth has been on this case for some time, and I am newer to the case. I'm not looking for a personal accommodation, but I think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably, I truly believe it's going to have a more efficient and effective trial. A part of my perspective is to move as quickly as I can, and that's why I've started with the Rule 17 motions. I've also tried to retain as many experts as quickly as possible. The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to the defense. The defense then may have counter experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to January 27th, and I still am. If the court decides that's more appropriate, I will be ready on January 27th. However, I realized when I was trying to move and facilitate the testing of these ships in 2 weeks, and the government, the defense wanted more time, and I appreciated that there.
He slipped and said the government because he's so used to being a defense attorney that he's not quite sure which role he's in right now. Do you hear that? Taking it back.
On January 27th. However, I realized when I was trying to move and facilitate the testing of these ships in 2 weeks, and the government, the defense wanted more time, and I appreciated that their request was reasonable. I began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get into a position where we're turning over expert testimony, they're retaining experts to counter that testimony, and then to reciprocate in discovery where days, weeks, or in the midst of trial. I want to avoid unfairness to the defense at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery. And certainly, the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full.
I just want you to, if you're not looking at your screen, come look at your screen and look at Adam Lalley's posture, the way he's hunched over. It's a beaten down man. Sorry, Adam, they took it away. They took it away from you.
And in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided.
So they brought on your full-time paralegal from your private practice, so now the Commonwealth is paying her too? Is that what he just said? Does she get a separate contract? Where are my public records, people? He's already under contract for $75,000. Bob Mata, I know you're here. Allie, I know you're here too. $250 an hour is what he's making for this. He's a highly skilled criminal defense attorney who represented Whitey Bulger. And he's coming in as the hired gun because nobody at the Norfolk County District Attorney's Office wants to retry this case. And they're paying him $250 an hour. Why? Why would he take this case?
Legal. And we are going through the entire discovery. And I know it's already been provided, but it wasn't Bates' numbers, which I'm accustomed to. And we are re-indexing all the discovery and re-providing it, even though I expect most or all of it has been provided. And I'm doing that out of an abundance of caution so I can be confident that the defense has every document I have. That will resolve or prevent any delays at trial of inadvertent late disclosure or any concern or confusion about documents that have been provided. I also, with the office, have diligently moved to obtain all Rule 14 statements so that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it. I give it to the defense.
He's like, I'm going above and beyond already, Your Honor. Look at me. Look at me. Look how great I am. I'm already going above and beyond. I'm giving them everything, whether I think they're entitled to it or not. Like that random email from the guy on Twitter who said the key cycles were wrong. I said that to them, sent that to them right away. Even though I don't really have to, I'm going above and beyond, and good, as well he should.
And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial. And it will allow me, when I evaluate this case, which I'm still in the process of doing, of
still evaluating it,
reducing the witness list substantially. And
you mean
so
you're not going to call every single person who ever
motion,
walked on the sidewalk past 34 Fairview this time? You're evaluating the witness list and it's going to be considerably shorter? Is it because of all the law enforcement that they called during the first trial are now under internal affairs investigation and or fired and or disappeared? Listen.
Delays at the time of trial, and it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially. And so although it does delay the case, if you allow this motion, I think it will make for a shorter, more effective, efficient trial. And I think it will be, importantly, more fair to the parties involved. And that's why I asked you to consider that continuance. I do not expect I would come before you and ask for another continuance. If something cannot get done in time with an expert of my choosing or that I would like, I appreciate I won't be able to use that expert. And so I think the joint request is something that is legitimate. I think it's well thought, and I leave it to Your Honor. Thank you.
All right.
Where's my
Who's
court
going to argue
reporter?
this for the defendant?
I will, Your Honor. I'm not going to belabor the point. I mean, not surprisingly, in a joint motion, I agree with the argument made by Mr. Brennan. You've heard that there will be new Commonwealth experts. There are no reports yet. There have been no disclosures. No forensic testing has yet taken place. And the timeframe, according to the motion, is somewhat unclear at this point. Clearly, once testing is complete, disclosures are made, we would have the right to consult with our experts and potentially employ additional experts depending on what the testing.
Have you been working on that though in anticipation?
We have,
Okay.
yes. Mr. Brennan has promised to index all discovery so that both sides can be satisfied that full disclosures have been made. I know he's been working diligently on that. He needs a little bit more time to take care of that. I would remind the court that during the last trial, we were still receiving reports and some discoverable material as trial was ongoing, sometimes deep into a trial.
Like the inverted Sallyport video that just magically appeared, and ghosts were appearing in and out of that magically inverted Sallyport video that your witness, who was called to authenticate the video, said absolutely was a fair and accurate representation of the way the Sallyport looked that day the video was taken. And it turned out that on cross, that video was mirrored. So what looked like the passenger side of the vehicle was really magically the driver's side of the vehicle. And so many of you in the chat pointed it out that some of the writing was backwards. And then they just acted like, oh, no big whoop. And I'm sure there was an objection and they went to sidebar. And that's why all these sidebars need to be unsealed, because we need to know what the discussion was and why in hell that video was ever allowed to be shown, because that was intentional.
And we're really trying to avoid that this time. It's really not fair to Ms. Reed that discovery is not complete well in advance of trial so that we can assimilate and incorporate that discovery into what would now be a retrial. And our position is, Your Honor, there's simply not enough time between now and January 27th to get all of that done and properly prepare for trial. And I would just close by saying that both sides and the court have an interest in having this matter proceed to trial expeditiously. But in our view, and I would expect in the court's view, the most important consideration here is Ms. Reed's right to a fair trial. And in light of what's outstanding and what needs to be done, we believe she would not be able to receive a fair trial at the end of January. We're essentially asking for a 2-month delay, which I believe is reasonable in light of what we've already discussed. We do not anticipate any further continuance requests, just like Mr. Brennan said. So we'd ask the court to allow this motion.
All right. What do you anticipate we need to do for in-court hearings? You mentioned in your motion, in the joint motion, a Daubert hearing. How many dates are we talking about? We already need a new date now for Rule 14, for the Rule 17 motions.
And
so we need to start moving forward with all of this. Is there going to be a Daubert hearing, and who is the witness that you anticipate a Daubert hearing on? I'd like to get that on our schedule now.
We have not yet drafted the motion, but I've given it much thought. The government at trial called an expert regarding a dog bite. Forgive me, I haven't watched all of the trial.
No, that's fine.
He said the government at trial called an expert regarding a dog bite. No, that was the defense, sir. Remember, you now are the government. They are the defense. The defense was the one. Her name was Dr. Marie Russell, who was a doctor who wrote papers on dog bites. He just said the government. Listen.
All right.
Much thought.
Now.
We have not yet drafted the motion, but I've given it much thought. The government at trial called an expert regarding a dog bite. Forgive me, I haven't watched all of the trial.
No, that's fine. All right.
That expert, I do not believe, followed the proper methodology or had the expertise to make.
All right. Does the defense intend to call Dr. I've forgotten her name.
Dr. Russell.
Dr. Russell, do you intend to call her again?
I expect that she will be on our list.
All right. So why don't we set a Daubert hearing sometime in December? Does that give you enough time, Mr. Brennan?
It does, Your Honor.
Okay. So
She's
why
in
don't
California.
we set a Daubert hearing? I know you'll have to fly her in, but why don't we get a date now in December for that?
Does the court anticipate that being a different day than the date we're going to set for the Rule 17?
Rule
motion?
17, we're doing as soon as possible. We'll do before
Understood.
that day.
Understood.
Yeah, so we should fly Alan Jackson back twice. Let's not do it all on the same day and make it easy for the California lawyers and the California witnesses. Let's make Karen Reed spend more money than the $5 million she's already in debt to her lawyers for.
Maybe we can have a file. Another 25th.
So, Mr. McDermott.
May I approach Mr. Brennan for a minute?
Sure.
He doesn't know what side he's on, Caroline. He forgot. He said, oh, yeah, in the last trial, the government called an expert. He's the government now. Ooh, hot mic.
I think we moved both our trials yesterday.
I think she's talking to Jim. She says, I think we.
December be available for a Dalbert hearing? It's a Friday.
Possibly. I think we just put something else on this morning that would be time consuming.
I could also do the 12th if Mr. Brennan's available and my co-counsel.
I was looking at the 10th, but Jim, could you look at the 13th?
Yeah,
There's Jim.
The 10th work for both of you. The government's available on the 10th.
He remembered.
So I have you cannot do the 10th. Okay.
Your Honor, just to be completely candid, I have nothing on the 10th. I've got to fly out on the 11th, and I've got an all-day hearing on the 11th. So I'm sorry, I'm reversing that on the 9th. I didn't fly out on the 9th. And I've got an all-day hearing on the 9th back in California, so I can't fly that day. So
Well,
I fly on the 10th.
court ends at what time?
Oh, please.
You could take, a lot of people take a red eye, right? And they come out then?
I do every time.
You can take a red eye, Mr. Jackson. A lot of people take a red eye, Mr. Jackson. You could take a red eye. That's the way we do things here in Massachusetts. It's a privilege for you to be here, Mr. Jackson. It's a privilege for me to even let you be here, Pro Agvice. Are you kidding me already? Already with this? Oh, yes, she did, Crystal.
You can't fly out on the 9th, the evening of the 9th?
There's no way I can't take a flight on the 9th.
What about the 16th? It's a Monday. Is that?
We're fully booked that Monday and Tuesday.
Let's stick on the 13th. Are we still on the 13th?
Sure, if it's available. We
13th?
Jim, we just put Gaston on for that day.
A lot of people take a red eye.
Competency hearing, and we also do on Gaston.
You had to adjourn the Verizon motion because your new attorney that's getting paid $250 an hour didn't know that he had to serve the third party Verizon with that motion. And so
Did you say
now
the 12th?
this is almost completely a waste of time.
The 12th works.
I can do the 12th.
I can do the 12th.
We'll accommodate, yes.
All right, so the Darbert hearing will be December 12th.
That'd be at 9 o'clock, Your Honor.
Yes.
Oh, yeah, she's for real.
All right.
And those motions should be filed on the 27th.
We'll get a date on that in just a minute, Jim. When are you available for the Rule 17 motions? How about November 26th?
Oh, yeah, the day after Christmas. Let's do it that day, Your Honor. Let's let Alan Jackson fly in on Christmas so he can be there with you on December 26th. Are you ducking kidding me? So he can take a red eye from LA on Christmas night and leave his family to come spend Christmas the day after Christmas with you? When most courts are like not even doing business between Christmas and New Year's? This is rich. Because she's taunting Alan Jackson to say something again, because now she feels like she already accommodated him on December 12th. So now she's suggesting the day after Christmas.
Morning
Where?
in Woburn District Court. To the extent that the court would give me a protective order, I can do
Or tell them that you have a trial here, and if I need to speak to anybody, I will.
Okay, appreciate that.
We're not a trial here, but this motion hearing.
Okay.
I'd like to do it as soon as possible to get those out, get that moving.
Thank you.
Oh, she said November?
So November 26th.
Oh,
Jim, can we
sorry.
do
All
that in
right,
the
I made a
morning?
big deal of
Yes.
nothing. November 26th?
I'm told that Mr. Jackson cannot make the 26th.
For the Rule 17 motions, do you need to be here in person?
If I can have 10 seconds.
You know, that's 48 hours before Thanksgiving. Most people do take that week off.
During
Yep.
this moment, if I could just alert the court that there is one additional Rule 17 I'll have filed by Friday. It is similar to a number of,
File it and send notice immediately of the date.
may I inquire, do I send notice on behalf of the Commonwealth or does the clerk's office send it?
Mr. Lally can inform you on the process, but
Thank you very
you
much.
send it right out.
We will. Thank you.
Yes.
Okay. Yeah, we'll make the 26th work.
Great.
I likely will not be here, but she
Okay.
will be right.
Are we 9 AM?
Why don't we do 10 a.m., Jimmy?
10 AM. on
Get all the
26th.
record holders who want to be here.
Let's ruin everybody's
10 AM on the
Thanksgiving week.
26th.
All right, and all the other motions are taken under advisement.
Great.
Okay, thank you very much.
Thank you.
So she basically decided nothing. Nothing, other than she'll unseal the sidebars.
Mr. Clerk, whenever you have a minute.
You are muted.
That's what strength looks like. There's Karen Reed. Other than releasing sidebars, it's going to take weeks to get all those transcripts together because they're going to need to have 3 court reporters working on it like around the clock. So there's that. Let's take a look at the new discovery dump that the Commonwealth just dropped last night because we were lucky enough to get a copy of that. Thank you to Jonathan for that. Yeah, sorry. She did say December and then November. She meant November, but she said December because I thought she said December the first time too. Regardless, it's Thanksgiving week. Is anybody else buying tickets like for their kids to come home for college, from college for Thanksgiving week? Do you have any idea how much plane tickets cost that week? Thanks, Jonathan. It's insane. It's insane. But you know, it's Bev's world. We're all just living in it. I don't think she's even decided whether or not she's going to continue the trial until April 1st, right? She didn't, she did not really rule on that, did she? No. Nope. The motion to release Morrissey's emails. The Commonwealth did not even respond to it. So they're going to have some time to be able to respond to it. He's going to need at least 10 days to review that. Hank Brennan, who's kind of confused about who he works for now because he kept calling the defense the government, and he's the government now. I know he's usually a defense attorney, but I don't know why he's doing this for $250 an hour, Bob said. And that's exactly what I said. Like, does he want to run for DA? That was my initial thought. Like, maybe he wants to run for DA. And this is his way in. I don't know, because I think we can all agree that Morrissey's probably on his way out, despite the fact that he's run unopposed ever since he took office in something like 2010. So whole lot of nothing today. And again, more expense. First thing that happened was the Rule 17 motions where the Commonwealth wants Verizon records from Karen Reed's father, which we went over yesterday, why they're not entitled to them, because everything that they're looking for, they already have and have had since the day that Michael Proctor seized her cell phone on January 29th of 2022. Any communications between Karen and her father are in that report. And despite that, Hank Brennan, who does practice in Massachusetts, by the way, didn't understand that the proper procedure was that you also have to serve the third party that you want the records from with the motion so that they have the opportunity to come in and be heard if they so choose. And oftentimes they choose not to come in and be heard, and they just send a letter that says that. But again, they could not argue that motion today. Then Mr. Brennan said that he filed 2 more Rule 17 motions last night. We're going to go to the court docket and take a look at what potentially he's also looking for from other third parties. Then we listened to the motion to release the sidebars, and the Commonwealth did oppose in part. They wanted only released to counsel. I think that he was also confused because he said, I can't really review them until you rule on this. And she said, oh no, counsel can review impounded stuff. So you actually do have the ability, Mr. Brennan, to review that stuff if you like. And he said, okay, I'll get started on it. I think they agreed to keep the juror list impounded, at least anyway, for now. The motion to release Marcy's emails, like we said, the Commonwealth does not oppose it yet, but they do want to. So they need at least 10 days to review that. And he did reinforce to the court that he's releasing everything, even as it comes in, whether he thinks they're really entitled to or not, because he knows his obligations under Rule 14, and therefore he's absolutely releasing everything that they're entitled to, like, internal affairs investigation reports and, random emails that he gets from strangers on the internet. And I have November 27th written down for that. And I'm not sure if that was a hearing date or what that was. Then we got into the testing of the telematics system, and you're going to need somebody far more intelligent than I am with regard to those kind of forensics to tell you whether or not the Commonwealth's new expert, Shannon Burgess, knows the difference between a gigabyte and a gigabit, which apparently he doesn't. But Mr. Brennan seems to think that his new expert is very astute, Mr. Burgess, and that the Commonwealth's expert should not, the defense expert should not be allowed to participate in any of the retesting. They can only observe the retesting. So, there's that. It's going to take 3 days to do that testing. And in Hank Brennan's words, it is very urgent that we do this quickly because time is of the essence here, because we have a new accident reconstruction expert who's going to need the results of that testing before we can move forward with his new theory on how John O'Keefe didn't get hit by a car. So that's what they're going to need. And then apparently the defense got up and said, Trooper Paul didn't know how to do a chip off, Your Honor. And that's why our expert had to do it last time, because Trooper Paul kind of deer in the headlights, kind of like when he was asked about the definition of kinematics or velocity on the stand. And he was like Cindy Brady when the red light went on. If you know, when she was on TV that time. He explained also that it's not that the information doesn't exist. It's that Burla had updated their software. And so it's not that the data was missing, but that it's unreasonable. We don't oppose getting any other information that happens to be held within that device. We don't oppose getting it if it exists, but we want to be there for it because we don't trust their new expert. And Hank Brennan got back up and said, well, they don't have veto power. The defense does not have veto power of the testing. They can be there, but they're not allowed to touch anything. So she said that she's going to, I guess, rule on that at some point. We still don't know when. He also told us that he's bringing in his own paralegal to help him evaluate the case. So I'm curious to see if there's any sort of contract with regard to him bringing in his new paralegal, or if she's just going on the Commonwealth's payroll, or how much more money is Norfolk County spending on this re-persecution. We don't know if we still don't know. She didn't agree. She didn't agree to put the case over, the retrial over, until April 1st. And Hank Brennan said several times he's still evaluating the case. He's still evaluating it, but that he thinks that even if you do grant this extension or this continuance or this adjournment until April 1st, Your Honor, it's really going to save time in the long run, because I'm actually going to cull down the witness list substantially. I'm going to reduce the witness list substantially. So it's going to save trial in the long run if you agree to adjourn to April 1st, which the defense is in agreement with. But as you know, during the first trial, even though both sides agreed that they did not think that any of the harassment evidence should be allowed to be talked about by the witnesses, the court said, well, basically, screw you. I don't care what you guys agreed to or what you stipulate to. I say if the witnesses bring it up organically, it's coming in. And they did bring up their witness intimidation / harassment organically. Several of them did. At least 3 that I can think of: Allie McCabe, Jennifer McCabe, and Colin Albert. So they brought it in organically. Let's just say that. Then we learned that Hank Brennan would like a Daubert hearing with regard to one of the experts that testified in the first trial for, he said, the government, but we know it was really the defense, who had Dr. Marie Russell come in. In fact, Dr. Marie Russell reached out to the defense herself because she was so outraged by what she was seeing, that people were saying that the injuries to Officer John O'Keefe's arm were not from a dog bite. She's an expert in dog bites. She reached out. She said, I think I can help. And she did come in. There was a Daubert hearing with regard to Dr. Marie Russell, and her testimony was allowed in the first time. So now that has been set for December 12th. They need to fly in Dr. Russell from California. And at 9 a.m., there's going to be a Daubert hearing on that. But no, we couldn't do everything all on that day, knowing that Alan Jackson has to come in with his team from California. No, we're going to do the Rule 17 motions now due to Hank Brennan's error in not serving the third parties on November 26th, which is 2 days before Thanksgiving. And I think that Alan Jackson said that he could not make it on that day. Could he appear by Zoom? I don't even really know what she said, because I was kind of outraged at her statement when she said to him, because he had a conflict on one of the days. He's like, I would have to fly out on this day and come back on this day. I can't fly on that day. She said, well, people take red eyes, don't they, Mr. Jackson? Can't you take a red eye? Are you ducking kidding me? Are you ducking kidding me? So it's, SSDD. If you know, you know. Same stuff, different day. Let's take a quick little look-see at the new discovery drop that came out that Jonathan, our amazing paralegal, was able to get us a copy of. And Olivia, if you're still here, I would love your help in trying to decipher what some of this stuff may be, because it's not really that specific. It just kind of refers to certain documents. So let's take a look at this and see what we can glean. I'm going to look to the chat because you guys are so, as always, collaborative. This is the Commonwealth's Notice of Discovery number. I'm going to go with 49, XLIX. I believe that's number 49. And this was filed yesterday after 4 p.m. It was not available yesterday in the court docket, but our amazing paralegal Jonathan was able to get a copy of it for us today. So here we go. New discovery dump from yesterday. And here is what they are exchanging with defense counsel. Number 1, copy of the Massachusetts State Police Office of Professional Integrity and Accountability report with a case number. This is an internal affairs case number. Let me highlight. Let's say no. So it doesn't say who it's regarding, but here's the internal affairs case number as previously provided by Massachusetts State Police via Rule 17. It's 1 page. That is a March 4th, 2024 internal affairs investigation. Which one of the many players in this case is that regarding? I'm not sure. Whoops. Sorry about that. Not sure. Maybe Fanning. Maybe Fanning. Wasn't he the first one that was cleared? And then number 2 is a copy of the Massachusetts State Police Office of Professional Integrity and Accountability report with a different, actually it's the same case number, dated March 4th, 2024. That is 1 page, and that is 1 page. So I'm not sure what the difference is, but it looks like it's the same case number, so it's probably regarding the same law enforcement officer. Number 3, same case number, copy of an MSP Office of Professional Integrity and Accountability. It's another 1 page report, but that one's dated March 19th of 2024. I mean, can we assume that the same case number means it's regarding the same officer or lieutenant? Somebody with the Massachusetts State Police, maybe a supplemental report with regard to that same person. Then there's a copy of the curriculum vitae of James Crosby, 11 pages long. Not sure who that is, but somebody I'm sure will look him up. Maybe that's their new accident reconstructionist. We'll see. Here's number 5, a copy of the list of materials that were sent to James Crosby. So obviously he's an expert, and the materials that they sent to him to review are all included there. They list all the materials they sent to him to review, to render his opinion. That is 1 page. And again, can we please just, it's Bates stamp, not bait. Bates. Oh, well, I didn't mean to do that. Number 6, copies of engagement letters with James Crosby, 4 pages. So that is the retainer agreement that they sent to this new expert, apparently. And maybe it says how much he's being paid. And again, engagement is spelt wrong. That says engagementet. It's an engagementet letter. Engagement A, if you prefer. Engagement A letter. Does anybody flippin' proofread in the DA's office? I mean, that would have been picked up by spell check, but no. So it's a 4-page retainer agreement with that new expert. Then there's some emails here. So the 7, 8, 9, 10, and 11 are emails. One's dated July 22nd, 2024. One is, and that's 2 pages. One is 3 pages dated October 31, 2024. Happy Halloween. Another one is 1 page, November 2nd of 2024. And then there's an email. When he says he's re-indexing everything, that's what he means. He is now putting Bates stamps on everything. And NDAO is Norfolk District Attorney's Office. And he's stamping everything that comes in. That's what he means when he says he's re-indexing everything. Because I can only imagine Lally's filing system is probably like a big Michigas of paper, a big like just like papers everywhere. Can you just imagine like red wells exploding and files tearing and papers on the floor and nothing is stapled? And I guess he's trying to organize it, but they're paying him $250 an hour to do it. So that's good. Then there's another 1-page email from November 3rd, another 1-page email from November 11th. And like he said, you just heard him say, even random emails that are just coming to me from strangers, I'm exchanging all that stuff, whether it's exculpatory, inculpatory, whatever it is, I'm giving it to them. These could be random emails from random internet people. Somebody said, could they be the Betero letters? I don't know. If the Betero letters were served on them. They could be 1,000-page binders. Yeah, with like everything with like, those little, remember the reinforcements that you used to have to use on loose leaf paper to put it back together? This is interesting. So here's a Mansfield Police Department report, a 2-page report from November 17th of the year 2000. Well, we know that Karen lives in Mansfield. Was this some sort of dispute she had with a neighbor 24 years ago? Really? Wasn't there something floating around the internet about an argument she had with a neighbor about a noise complaint or something? Maybe. Was that what it is, Mindy? Yeah. Like that's going to be relevant material or evidentiary at all. But again, he's at least I'm going to give him props for exchanging all this stuff. Here's a Waltham, I don't know how you guys pronounce this, police department CAD sheets, CAD sheets. 2 pages from February 16th of the year 2000. 24 years ago, something happened in Waltham, or I know you guys taught me how to pronounce Leominster, so that's cool. Hank thinks Hank is great. XOXO, respectfully submitted for the Commonwealth, the government, and or the defense. Not really quite sure which hat he has on today. XOXO. Hank Brennan, the specially appointed district attorney. Then he gives Adam Lally a signature line and Laura McLaughlin. Waltham. Thank you, Waltham. Waltham. Wow. Okay. Well, he said he filed a couple of other things last night. So let's take a look and see if we can glean from the docket what those things are before we're even able to get copies of them hot off the press. The Mass Court's website has this weird thing now where yesterday they were making me click pictures of a motorcycle, click all pictures that have a motorcycle in them. And then, invariably you get it wrong because there's one little thing that could be a little tiny piece of the motorcycle and you got to do it again and again and again. So I guess they have some non-humans trying to get into their computer system, but. Oh, everyone's trying to get in right now because we're getting that whole big buffering sign. Let's see what the docket says for today. He's earning that $250 an hour. If he's not already through that $75K, I'd be surprised. I'd be surprised. All right, let's see what it is. So we just looked at docket number 415. 415, we have it. So what we're missing is 416 and 417. 416 is the Commonwealth's motion for a protective order for the phone and iCloud digital forensic device report. And that was allowed. So is that something that we already looked at? And now they've impounded it or sealed it, as they like to say in Massachusetts. They say impounded. Let's take a look. Number 416, Commonwealth's motion for protective order regarding phone iCloud digital forensic device report. And it was allowed with no opposition by the judge today. She maybe just scribbled in the margin, allowed. And then docket number 417 is the Commonwealth's motion for a protective order for document from pending internal affairs investigation. And that too was allowed. So those are two things. He may have filed some more things that are just not even in the court system yet that we don't have access to. We'll see. He did say he was going to file some more Rule 17 motions, which are motions for third-party discovery from people who are not involved in the case. Let me see what I did not get to over here. I think I did talk to Chief Sherry about this and your caffeine, and thank you for the 10. And thank you, Jolie Loves Law, for the 5 loves watching and learn so much about the law. Are they showing the fan yet? No fan in this courtroom, sadly. Different courtroom today. Stephanie, backup paralegal reporting for duty. Yes, that's right, Stephanie. Thank you. Stephanie is also an amazing paralegal who also helps with so much behind the scenes. And I don't like to shout you guys out unless you say it's okay, because I know some of you like to remain anon, please. And that's totally, totally fine with me. So thank you, Stephanie, for your help as always. Maureen Gunn, thank you so much for the $20 super sticker. Always appreciate you. And Laura, miss y'all. Miss you too. Been on Rewatch Crew. Thank you, Laura, so much. Michelle, I'm here for it. Let's go. Free Karen Reed. Thanks for the 5. Amy's Positive Pathways has been with me for 3 months. Hi from Massachusetts. Love the baseball cap look. Amy, thanks. It's early. It's early. Edward Kirkpatrick, she argued a motion a fair amount for Lally. Yeah, she did argue a lot of the motions for Lally, or she would also help him with his objections too. Mr. Lally, do you want to object? Do you want to object, Mr. Lally? And she did not allow grounds to be stated for objections, which is highly unusual, but was that another softball, here, I'm going to help you out. And so therefore, if you're not allowed to state grounds, all grounds for objections are arguable on appeal. Cuzzy Farm, go to Young Jerks. He's got the full courtroom view. That must have been earlier when we did that, but no, I don't restream other people's streams because that's their work, not mine. So thank you for pointing me in that direction. Or if you were trying to tell other people to go over there and watch it, I would say that's not a cool thing to do, but I would never restream another creator's work. It's their work, not mine. I don't play that game. Kirsten, pay no attention to those in the back. Prosecutions backs to the defense makes me outraged. I agree. And you're looking at us from Canada, and it's a bad look. It's a bad look. Okay, doesn't the prosecution decide when to try? I have no sympathy for Lally. They don't decide the trial date. No, that's decided by the judge. So they're both in agreement that they want to adjourn it to April Fool's Day, coincidentally, or maybe not coincidentally, or ironically, or isn't it ironic? Don't you think? A little too ironic. And yeah, I really do think that April 1st would be appropriate, but we'll see what she says. And you also have no sympathy for Lally. Thank you for your thoughts. Lally looking like Duck My Life, says Cheyenne Brown. Yeah, he was all hunched over. He was like, who's the guy from, what was that? Well, that Hunchback, not The Incredibles, but it's something similar to that. I want to say like Invisible Me or Despicable Me or something like that. Who's that? You can tell me. You can tell me who that character is. I know you know who I'm talking about. Despicable Me. I don't know. Jeevy, thanks for the super chat. Delphi verdict really affected me, and I thought of taking a little break, but I feel better here at the Karen Reed hearing with Melanie and chat. We'll join as soon as I get done feeding the horses. Oh, thanks, Jeevy. Thanks for coming in. It was Gru. That's right. It's Gru. GRU. And what movie was that? I mean, that was like it was an animated movie. That's what he looked like. Gru. Thank you to those of you who guessed that in the chat. Alternate juror 3. Are you just here for Saturday? Not just one day. No. Thank you, alternate juror. That's so Jessica. Thanks for the 5. Y'all, I'm headed to get coffee. You'll be coming with me. What's your coffee order, everyone? Oh, don't even go there. Is there enough coffee to even get us through this day? Aaron Fleming Knowles, thanks for the 10. Thank you, Melanie, for your honest and authentic coverage. Your legal insight helps my sanity while following this case. I love watching with the cupcakes. We do have the best mods on YouTube. We do. And we have the best mods on YouTube. And we also have the best chat on YouTube. You guys are the Snark Tank, and you are fire. Thanks, Cal, for becoming a new member. Nancy, thanks to the 5. If this North Jersey girl can stay sober for 28 days today, congratulations. Congratulations, Nancy. Amazing job. Keep it up one day at a time, girl. One day at a time. Then Bev can make a mother ducking decision from the bench for my anniversary. Well, did she though? I mean, she decided on some dates. Is that good enough? Thanks, Nancy, and congratulations. JSMP Jen, you went to your first hockey game. Go Panthers. Didn't you love it? Isn't it so exciting? Isn't it so fun to go to a hockey game? Thanks, Jen. But I'm going to say, let's go Rangers. The biased juror, hearing Bev's voice, it's like going home to a dysfunctional family for the holidays. Thank you for the 5, biased juror. Edward, does she not read these motions at all before the hearing? She asks questions that are literally in the motions submitted to the court. Lazy. She's supposed to. Whether she did or not, I don't know. She didn't remember Dr. Marie Russell's name either. Latina, the appellate lawyer for the Commonwealth, is there. Interesting. Thank you. I also believe Karen Reed's civil attorneys were in the courtroom today. So for those twidiots out there who don't think that the attorneys on both cases are working together and or strategizing, because both cases are going down the same pike here. Everybody wants the same result, right? You are mistaken, my friends. Alan Jackson coming in hot with the facial hair, says Erica, 2 minutes. Thanks for the deuce. LA, if sidebars are released, please drama reading with Clara. That would be amazing. Yes, if we got a hold of them, that would be such a great idea. Thanks, LA. Misha, thanks for becoming a YouTube member. You'll notice Glamma Suze was not in the chat today because she was in the courtroom. Olivia Nile, who is a technology wizard, a wizard on all things technology. And if you don't follow her on Twitter, follow her on Twitter at Olivia Lambo. She's way smarter than I could ever hope to be with regard to all of the forensic type stuff. Says, I think Brennan is confused. It's not a matter of not having the data or not filing a search warrant for it. It's because the software Burla, which reads the data, didn't have an update yet for Karen Reed's car. Yes, despite Trooper Nick Garino's best efforts to go to the sales conference, try and talk to the person sitting behind the Burla table, which is what he kept telling us that he did when he was on the stand. George King, Papa George, good morning. Thanks for hanging out. This is Free Karen Reed. Vivian, in honor of Jake Paul versus Mike Tyson, who'd win in a fight, Bev or Gull? Oh, Vivian, that's a great one. I think I got to go with Gull on this. You guys can chime in the chat what you think, but if I was going to bet, I'm not a betting person, but if I was going to bet, I'd say Gull. I say Gull would kick some Bev butt. She seems tough. Wildman's mom, how can you redo the accident or do the accident reconstruction? You don't even know where he landed in the yard. No pictures or drawings, right? There's no measurements. There's no outline of the body. There's no marking where the body was. You know, anybody who ever watched Criminal Minds or Law and Order or any crime show ever knows about those little yellow, like, cone things with numbers on them where they put them around the yard with evidence. And then, they photograph things and measure things. No, they didn't do that for Boston police officer John O'Keefe's body. So, we're not really sure where his body was. And that's a great point. You guys are wicked smart. Frick and Frack, thanks for becoming a member. George King thinks AJ would look better with a goatee, in his opinion. All right, George, I'll allow it. Thanks for the 10. So Ty, thanks for the 5. Although John O'Keefe was evidently not hit by a vehicle, the car data may lack GPS, and Karen may not use phone navigation. Remember the trip to 54. The trip to 34, I think you mean, 34 Fairview Road, by the way, not Fairview Drive, as Michael Proctor put in his search warrant. Yeah, that was on John O'Keefe's phone. He put that in his Waze phone. But even if you don't put an address into the navigation system, your car still tracks where you're going. Your car has a lot of information in it, and P.S. they report it back to insurance companies. They know how fast you go. They know how much you drive. And also that information may exonerate her. The defense is not afraid of obtaining that information at all. Courtney, this is smoke and mirrors. Thanks. Thanks for the deuce. And then Olivia says, yet the Commonwealth gave Ian Whiffen a Celebrite extraction that was stripped of its hash value, suggesting that it was tampered with. Right. Hang on for just 1 second. Talk amongst yourselves for 1 second. Exactly. And yet they're afraid that, the defense expert is going to do something to tamper with something. That's interesting. Can they request a video of it, says Good Citizen? Well, this is going back to 10:46 a.m. and I'm not sure what you're asking a video of. Of what? I'm not sure. Of the chip-off procedure, I just don't know. If you want to put it back in the chat, hopefully someone can draw my attention to it. Bob Mata wants to know, any idea on when the opinion from the appellate court ruling is coming down? I mean, could be between 60 and 90 days. Hopefully they'll expedite it because The trial is still supposed to take place on January 27th. She has not ruled on whether it can be adjourned. I think she's going to have to adjourn it based on all of the new experts that the Commonwealth wants to call. But typically, I think somebody said they take somewhere around 80 days. You guys in the chat can correct me if I'm wrong, as always. Thanks, Bob. Amber, thanks for the 10. Auntie Bev's tone is the same as my toddler being annoyed. I asked him to eat dinner. His condescending tone is so cringy when dealing with the defense. Her condescending tone, you said, and I read it wrong. Yeah, I know. You can take her. Don't people take red eyes, Mr. Jackson? Can't make it up. Mama She, wow, this guy is so icky. Thanks for the 5, Mama She. Loudmouth Tom should show up with his arm in a sling and some crutches. Thank you for your super chat. Lori Life 360 for the win. Thanks for the 10. I'm surprised she didn't tell him to charter a flight. Yeah, not just take a red eye. Why don't you charter a flight, Mr. Jackson? Aren't you rich? Aren't you, smooth as butter from, California and all? Maybe you should just charter a plane. Exactly. Thank you, Lori. Neil, thanks for becoming a member. Oh, rewind. Look at Karen Reed's face when Bev said, take a red eye. Sorry, I'd closed it out. I had too many tabs open. But if you guys want to go back and look at that, that's probably amusing. And I'm surprised that she didn't say something like something funny, Ms. Reed. Thanks, Latina, for the super chat. And Sweet for becoming a member. And AJ's beard. Oh, you guys, the way you change your names is just so fun. AJ's beard says, Bev doesn't care about money. She acts so put out. Yeah, she acts so put out. Like, no, I have a full day that day. Mitsame, thanks for the 5. I'm a very nice person, and yet Bev fills me with rage. Does she not have any self-awareness? What the actual duck? I can't. Thank you so much, Mitsame, and for sharing your thoughts, for your super chat. Fun size, thanks for the 10. Says, I think the judgy judge needs to get ducked with some good D. She's a miserable one, ain't she? Thank you, Mel, for all your covers. Thank you. I wouldn't have read that out loud if I knew what it said, but thank you, fun size. Laura, I need some benzodiazepines to watch anything Karen Reed. Duck, thanks, Laura. Not Fricker Frack. Marissa, look, she got right in there and changed her name like immediately as soon as Fricker Frack entered. Hank Brennan needs to put a note on his bathroom mirror. I am the government now. Yes. Oh, yes. Oh, yes. Oh, yes. Yes, we both. Oh, yes, we both reached. Oh, for the gun. Double M99. Thanks for the 20. Are a judge's emails subject to FOIL request if performed on a government email? Yep. And if they do government business on the personal email, that's when it becomes discoverable too. So, there's that. That's why they're trying to get Marcy's emails. Would have liked to hear that argument today. And the judge even said, I thought we were going to argue all Rule 17 motions today. That's what I thought we were doing here. But no, Brennan wasn't ready. Fannie Ray, when the officers take the stand, key question, what's your status with the department today? Some fired, transferred, retired, or resigned speaks volumes about their involvement or negligence in criminal actions 100%. 100%. And you can bet the Commonwealth is not going to be calling Proctor again, but the defense can. Dookie says, can we start calling Hank Brennan Hanky Panky? I'll allow it. Sure. Thanks for the deuce. Hanky Panky. Tracy, what happened to the Ted Daniels thing? Yeah, they didn't even address that. She didn't even bring it up. Did she even bring it up? I don't think she brought it up. Unless they're going to come back and do that all on the next date, on the November 26th date. Because I bet you, here's what I think happened. I think, right, when she was talking about the Verizon record, when she said, did you serve the third-party record holders? Meaning, he works for Boston 25, right, Ted Daniel? Did you serve Verizon and Boston 25 and Boston Magazine, Gretchen Voss's employer? Did you serve all of them with your motions? And he was like, well, no. those are all Rule 17 motions. So I guess those are all being put over to, November 26th, 2 days before Thanksgiving. So we'll be back for that. So there you go. I think she lumped them all into that same conversation. Something is so funny, Auntie Bev. If something hit the taillight hard enough to break it while the FUV was in the Sally port, would that register on the car's system? Oh, yes. Oh, yes. Oh, yes. I think it would. Whether the car is turned on or not, Olivia. Olivia, great talking point there. If perhaps, hypothetically, somebody took a baseball bat or a hammer to the taillight while it was in the Sally port and the ignition was not on, would that register in the vehicle data system? That is no, you're the one with the big brain. Something is so funny, Auntie Bev. The Albert's handcuffs became a new member. Now it's just a competition. It's just a competition to see who has the best screen name, and that, my friend, is well done. 3 wizards and a lady, thanks for the 5. I'm still so confused how Fanning skates by. He worked with Farwell as co-workers, as Stoughton police officers before MSP. Just look the other way. Look the other way. Pin it on the girl. Thanks for your super chat. David, yet he doesn't know it's a Bates stamp. No. Nope, he doesn't, and he doesn't know that he's now the government. Thanks, David. Go Georgia became a member. Cynthia gifted 5 memberships. Well, thank you so much, Cynthia 1880. And for those of you like Charlie, who was gifted, is thanking you. And thank you, Charlie, for the super chat to thank Cynthia. See how nice you guys are to each other here? You guys are so nice to each other. Kirsten, formerly Auntie Bev's verdict form, is reserving my new name. Now engagement letter. Oh no, engagement letter. Or inter alia. That's good. Melanie's voice matters. Love it. Melanie's vote matters. I don't know. 8 days until I can file it. We might find some more in between, Kirsten. So don't jump the gun on this. Don't jump the gun. Engagement letter is very funny. Inter alia, it's a little banal, but we have time. We have time to help you find a new name. I'm sure the chatters would love to help you pick your new name. Charlie, or maybe can't you take the red eye, Mr. Jackson? Jackson's red eye from LAX. That would be a good one. Charlie is thanking Cynthia, so we did that already. Oh, sweetie, no. Thanks to the 5. John, I knew you looked this up. James Crosby's online expert witness profile says animal handler / trainer. Oh, if we're going to go there, defense needs to get on speed dial to Garrett Wing. Garrett Wing, who's got, how many millions of subs on YouTube, who came on my show and said 100% dog bite, who has the prosthetic arm to prove what dog bites look like. That's interesting. Oh, sweetie, no. James Crosby. Okay, clap back. Garrett Wing is your man, you guys. You guys who have watched that dog bite show that I did with him, that was a great show, right? Thank you, oh, sweetie, no, for looking that up. Ms. Holmes, did you hear AJ's response to the red eye? He said, yes, I do it all the time. I did hear that. But, coming here on the red eye, he also gains 3 hours coming here, which he makes up on the way home, but still. Good citizen, if Bev doesn't allow the defense to have their own expert to review the chip, can they hire a professional videographer to watch the process and ensure no corruption this time? Oh, yeah. Well, they've got Craig already on the team, and he may do something like that, or have a guy on his team who does something like that. But they're not objecting to the defense expert being there. The defense expert has 100% the right to be there for it. They're objecting to the defense expert touching anything. So that is what you meant before when you said, can they videotape it? Got it. Thank you, good citizen, for another 10. Bite my bits. Oh, that's great. We got stiff competition here for best name. Are we going to see those sidebars? I don't think we're going to see them. I think the attorneys are going to see them. That's my gut. She doesn't want to see she doesn't want the public to be able to see what her rulings were at sidebar. right now before the retrial, we're going to be picking them apart. It's what we do. We analyze, we commentate, we say some of the hard truths that other people are afraid to say. Some of the stuff that we get blasted on the cesspool of Twitter for being right about, because you know you're making a difference when people come for you because they're scared that you're making too much sense and that people are listening. AJ's Beard, formerly Darla the Human, thanks for the 10. Mel, I lost my Wi-Fi. Did Bev deny the motion to move the trial date? She didn't decide yet. She didn't decide. Under advisement. Oh, Kelly Reed is here. Kelly Reed is here. Hang on. Thank you so much, Mauve Arts, for your super chat. It's dog bite, not gigabyte. Well done. Well done. Qbert. Hi, Qbert. Qbert went to court. Qbert was in court today. Hi, Qbert. I was so good at that game. I really was good at Qbert. Heading back from the court, more confused than before I went. Looking forward to your feedback. Well, Qbert, that was just a minute ago, but you can rewind. I had a lot to say. We all had a lot to say. We were feeling all the feels. Crosby is an expert on dog aggression. Well, then, my friends, so is Garrett Wing. So is Garrett Wing. Dr. Russell was an expert doctor on dog bite injuries who had written papers on the subject. But I'd put James Crosby, I keep thinking of Crosby, Stills and Nash in my head, against Garrett Wing any day. Any day. Little Green says, I hope the appellate court sends Bev a clear message, preferably one that involves red-eye flights on major holidays. Mm-hmm. That's right. Gull is the judge in the Delphi case, Sharon. Clerk Jim Clown. I think so far we have 10 contenders for best handle today. The public can't handle Auntie's side. Bye. Kiss my bits. Michael says in response to Samantha, yes, it had a backup camera. That was part of the data that the Commonwealth said was destroyed. Mm-hmm. This is true. Thank you. Olienka says the dog bite show of mine was the first you watched. Been hooked ever since. Oh, good. I'm glad you liked it. Kelly Reed put something in the chat. I'm not sure. Maybe it's a heart because on StreamYard it just comes up as a little square box that's hollow inside. But hi, Kelly. Hi, Kelly. I hope you guys didn't feel like time was too much wasted today, since nothing was really decided other than Hank Brennan doesn't know how to serve the third-party record holders on his motions, and he's going to make a couple more. Craig Cruden says, can't touch, can't intercede. If they are doing it wrong, can't stop it. She didn't rule on that yet, though, right? She said, I know that time is of the essence. So, I'll decide on this one quickly. That's what they want, though. That you're right, Craig, that they're asking that the defense expert can't touch, can't intercede. If they're doing it wrong, can't stop it. And Alan Jackson did have to point out, well, in the first time, the only reason that our defense expert did the chip off is because Trooper Paul didn't know how. Poor Trooper Paul. Gazzo, the square box that's empty inside is Bev's heart. You guys are fired today. Missed T and Eddie. I'd put Neil Young against him. Sharon's thanking someone for their membership. David Reese. Somebody help David Reese change his name. Garrett Wing. Yeah, it's Garrett Wing. He's the dog bite expert that I did the show with. You can find him easily on YouTube. He also has a website. I have his contact info if you need it. No, I didn't say that he does not testify in court. What I said was that I don't think that the judge would allow him to testify in court because he's not a medical expert. and he can't medically opine as to the injuries on John O'Keefe's arm. But if the Commonwealth is going to try and get a dog handler in to testify about dog aggression, then absolutely Karen should be allowed to call a competing expert, and I would suggest Garrett Wing. I said at the time that I did not know if he would meet, the Daubert or the Daubert qualifications under Bev, but he's not a medical expert. He's a dog trainer for his entire life who's trained canine dogs. So if they want to play that and she's going to let it in for them, then absolutely you can have a counter expert. 100%. Uncle Fredo says Karen was at Bentley University in Waltham in the year 2000. They are desperate. Double M, double nine. Thanks for the 20. So you could foil. I say foil also. That's New York. And I think it's easier than FOIA. It just rolls off the tongue better. You can FOIA request all of the judges' emails that may have been sent messages by Michael Marcy's burner account in an attempt to coerce certain judges. You wouldn't need Michael Marcy's phone and data direct. No, but don't you want to know if there's any surreptitious emails to Judge Cannoni? Because if he's willing to do that in the other case involving the Chris Albert restraining order on his private email to all the judges in Stoughton, does it strain credulity to think he might have sent an email or two to Judge Cannoni from his burner email? I don't know. That's why they need him. Or other people, other witnesses in the case that were not judges that were copied on that. Great point. Thanks for the super chat. AJ's Beard gifted 5 memberships. Thank you so much. You're sweet. Duncan, Idaho. Thanks for hanging around with me for 6 months. Says mauled to death by her SUV, hence the teeth marks. Yeah. Oh yeah. Go look for it. Jennifer Coffin, duh. DOH should be in the middle of that. Like, duh. Put a tweet out that she retweeted from one of the other Twidiots where there's a picture of the taillight and it is fashioned into pieces that resemble teeth. And their theory is that somehow the taillight hit John O'Keefe's arm, exploded into these pieces that look like teeth, and clawed his arm all at the same exact time. And then maybe he did a pirouette and was thrown 30 feet into the yard of Brian Albert. Go look for it. It's hilarious. It's funny. 30 feet from the street. Is that what it was? 30 feet from the street. Right. Became a member. Thank you. That's exactly what we were just talking about. AJ's Beard. I was gifted a membership, paying it forward. Come on, 100,000. Thank you so much. Thank you so much. Thomas T. Send lawyers ducks and money. That is well done, my friend. Thomas, that is well done. AJ's Beard gifted 5 members. Thank you. Thank you so much. Another 5. Woohoo. Kenny, thank you so much for your super sticker. I want to see if you could, thank you. Hold on. Question. What is Jen McCabe's maiden name? Anybody know? Anybody know what Jen McCabe's maiden name is? Weeks. It is Weeks. Okay. So she says in her super chat, thank you, Denise. Did anyone determine if Jen McCabe is related to Whitey Bulger's associate? Is her maiden name Weeks? And Whitey's guy was Kenny Weeks? I don't know if anybody has ever looked into that at all. But Denise, you're on fire. Thank you for your Venmo. Lori, Cisco Buffs. Laughing Lori, thank you so much. Somebody says no relation, no relate. They say no relation, no connection, not related. But Denise, that was a good question. I didn't know. I wasn't familiar with that. And to Nancy, who's grateful for my coverage. Thank you so much. And Allison, thank you so much for the Venmos, thanking me, and looking forward to the motions. You guys are amazingly kind and generous, and I appreciate each and every one of you so very much. All right. Any final thoughts, concerns, comments before we wrap for the day? What a day it's been. It's all just so crazy. Imagine your entire life being at the mercy of such a corrupt police force and incompetent, biased judge. It's a nightmare. It is. It really is. Let me see if I could find you that crazy tweet before we wrap, because you like, unless you've seen it, like, you can't even believe it. You just can't even believe it. For those of you who are interested, I went to the Danny Penny trial yesterday. I'm going to set up a stream on that. I just have to pull together some more research before I do. So you're going to want to make sure that you're subscribed. It's free. And you're going to want to make sure that you hit the bell so you get notified when I go live, because oftentimes it's not, you know, a lot. There's not a lot of advance notice. And the Daniel Penny trial is something that everybody should be following right now. And nobody really is. Nobody really is. I'd have to wade through like a million things to try and find this, but it is kind of worth it. So just give me 2 seconds and talk amongst yourselves for a second. Unless anybody knows exactly where it is and has it saved and can just shoot it to me. But it's pretty funny. The taillight pieces are shaped like teeth, and that's the argument. I wonder if the expert's going to say that. Are they going to hire an aggression and dog expert to come in and say these are not dog bites? And also, if they're going to hire that expert, they're going to need to give up where Chloe is, because Nicole Albert got on the stand and said, "Oh, I know where Chloe is. Chloe's in Vermont. In fact, I met the woman halfway that we rehomed her to. And I told the Commonwealth that that I knew where she was, just in case she was ever needed for anything in the future. I believe there was an objection. I believe there was a sidebar, and I would love to find that out. I would love to find that out. And if they're going to bring in this dog bite expert, let's bring in Chloe. Let's go get Chloe. Right? Where's this stupid moronic tweet? She doesn't delete anything, so I'm sure she never deleted it. But, you know, you got to wade through 7,000 tweets, mostly about how much she hates Karen Reed or me, to find anything. Do, 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 do. I thought I saved it, or somebody saved it or sent it to me, but we can't really spend too much time looking for it. But it's there. You feel like wading into the cesspool and trying to find it. That'd be great. And fun for your own amusement. It's the tweet that Coffin Doffer made about the taillight pieces that look like the taillight pieces look like teeth, and they were like really sharp little pieces that look like dog bites. I mean, that look like dog teeth, and that they claim that's how his arm was injured. That's the one. And it was Coffin Doffer retweeting someone else's theory of that. It was a picture of like literally of the taillight pieces shaped like dog teeth. It was crazy. Big Ben Lally. Thanks for the fact the wheels of justice turn awfully slow. I think the Alberts are descendants of some Irish boss. I have no knowledge. That it is a good time to point out that my viewers' opinions are just theirs and not mine. And thanks, Fairy Winged Butterfly, for becoming a new member. And I appreciate you so very much. And AJ's beard says, I heard they were cousins. I don't know. I don't know anything about that. I don't know anything about anything. I know nothing. Yes, but the sweatshirt had puncture holes, not rips. You are correct. Camille, thanks for the 5. As a veteran, it breaks my heart how someone who served our country and protected civilians is being treated like a criminal who had evil intent. That is with regard to Danny Penny, and I agree with you. I think he's a hero. How does sidebar info help, Karen? It helps them, Satai, thanks for the news. It helps them argue their motions in limine coming up with regard to the rulings that the court has already made and why those rulings are wrong and what they need to argue. So all of those evidentiary rulings were made at sidebar, and they need to have it to be able to go forward and make their arguments for the retrial. You know what? And that's it. All right, let me try one more thing, since you guys want to see it. I don't know. I just don't have time to waste on it right now. But I will see you guys later soon, I am sure. And thank you guys always for being here. Thank the mods, because they're the ones who make it such an amazing place to be, and a kind and supportive and funny place. And thank you to the moderators and to the viewers, replay viewers. Do all the YouTube-ish courtesy type things, such as like, hit, share, comment respectfully, be nice to each other. You know, SCO buffs, we coming. Be cool, be kind, be classy. It's not hard, I promise you. It is so not hard. Peace, everyone. Thanks for your support. Love you all. Have a great rest of your day.